Okay, so under direct discrimination, we need to look at what the comparators are to bring a claim, proof and remedies, and then the exceptions or the justifications for direct discrimination, which are very narrow. So Section 13 of the Equality Act is the starting point, and this says a person A discriminates against another person B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. So the key there is less favourable treatment. This isn't the same for everything under the Equality Act. If you are a pregnant woman, then Section 18 gives a different kind of ground to claim on. So it says a person discriminates against a woman if they are treated unfavourably. Okay. Now, Section 20, so that means, well, and the reason for that is that men aren't pregnant. So there is no appropriate comparator, and so therefore what matters is unfavourable treatment. In the workplace, you can still get a claim. You don't need to try and find a male comparator. Section 23 says that when you're looking for your comparator, there must be no material difference between the circumstances relating to each case. Section 39 just brings in the principle of that you've got a claim for discrimination into employment. It says an employer must not discriminate against a person in the way that they offer employment, in the terms of employment, or by not offering employment. And Section 83 sets the scope of who is protected. So you are protected in the case of employment, as Section 39 says, and employment is defined as having a contract of employment or a contract to personally do work, or applying for a contract of employment or a contract to personally do work. So very simply, we're looking at an expansive scope, a worker under the Equality Act. But there's a few things to mention we'll get to later, but essentially European law goes wider than this, and probably the Equality Act should be construed as going wider as well. Okay, so an illustration of the no material difference point is seen in Shamoon and Chief Constable of Royal Ulster Constabulary. So this was a claim for sex discrimination by Miss Shamoon. She had been stripped of her appraisal duties as a chief inspector because allegedly, there had been complaints about the performance of her in her job. She claimed that actually the complaints were motivated by the sexist workforce in Northern Ireland Constabulary, Royal Ulster Constabulary at the time. She was saying that the reason they're going after me, the reason that they're taking away my appraisal duties is because this is a predominantly male workforce. I'm a woman and I'm being unfairly treated and excluded as a woman. She picked comparators who did not have complaints that were made against them. And the House of Lords held that the absence of complaints being made against the male comparators meant that there was a material difference, and so she couldn't compare themselves and therefore couldn't make she couldn't compare herself to them, and therefore couldn't make out a case that she had been less favourably treated. Now, makes sense sort of if we describe it like that, but when you take into account the fact that or her allegation that the complaints themselves were motivated by the sexism that she was complaining about, then maybe the decision on the facts could have been decided better or differently. But bottom line for us at the moment is that when you're picking comparator, you've got to show less favourable treatment, and there's got to be no material difference between you and your comparator. So just imagine, also I suppose this is crucial to highlight as well, you don't have to have a real comparator. You can have a hypothetical comparator. Because of the word or would treat others under Section 13. If I'm claiming that I've been less favourably treated, I've just got to imagine somebody who has all the same attributes as me, but different race or different sex or whatever it is I'm claiming over, and that is what the court has to base their decision on. They can do a hypothetical comparator test. Okay, so EU law has moved beyond where the UK seems to be at the moment because of this case, JK and TPSA. And this was about a freelance contractor working for a television station. JK worked for 7 years at the TV station on monthly contracts. They were reorganized so that the contract was with a different department. JK did a video that was apparently problematic for the firm that supported gay couples. And after that, a new contract was not offered to JK. JK claims damages for discrimination based on sexual orientation. The Advocate General said any person at all should be protected under EU equality law. The Court of Justice didn't go quite that far, but it's held that under the Equality Framework Directive, which preceded and should be implemented by the Equality Act 2010, the directive protects people who work for a livelihood in order to realise their potential. The mere provision of goods and services is not enough to be protected. There must be some degree of stability in the legal relationship, but on the facts, JK certainly had that degree of stability and so could claim discrimination even though JK was not an employee, they were a freelance contractor. And so there's an expansive interpretation. And so if we think about some of the cases that have been decided under the Equality Act that narrow the scope of the application of equality law, notably Ex and Mid-Sussex Citizens Advice Bureau, we can see that the UK courts have not interpreted the Equality Act in line with the EU directives that it was meant to incorporate. Ex, remember, was about a volunteer working at the Mid-Sussex Citizens Advice Bureau claiming disability discrimination, and they were held that because they're a volunteer, they weren't within the scope of the Equality Act, based on an apparent purposive reading of the European Equality Directives. But what JK is saying is almost certainly that the scope is much wider and by extension, there's nothing in the Equality Act, Section 83, personal performance of work, that prevents a similar interpretation of the legislation. Because even if you're a volunteer, you are personally performing work, even though it's not for a wage. Okay, after we get over our comparison test, we've got to fulfill the burden of proof. Now, direct discrimination claims are often hard to make out without evidence that somebody has discriminated. Well, you can often see the evidence of disparate action, but less favourable treatment on grounds of a protected characteristic may be more difficult to make out. Often people don't say, yes, I was firing them because I am a racist. They don't say that. They will say they were firing somebody for some other reason. And then you've got to find evidence that the reason was racial grounds or grounds of sex and so on. So to make this a little bit easier, Section 136 of the Equality Act 2010, it reduces the burden of proof from what you might normally find. It says, if there are facts from which a court could decide, in the absence of any other explanation, that a person contravened the provision concerned, the court must hold that the contravention occurred. So in other words, if you can find a prima facie case that there is discrimination, the burden of proof shifts onto the employer to show that there's not discrimination. They have to come up with some credible explanation about why someone has been less favourably treated. So first illustration of that is King and the Great British China Centre. A Chinese lady was not shortlisted for an interview, and she showed the court, she gave evidence that all of the people who worked at the Great British China Centre, despite the name, were white. Why weren't there any Chinese people? Well, the court holds that we can infer from the fact that all the people at the Great British China Centre are white, means that there is probably some discriminatory practice going on. And so it was up to the employer to show why they that they weren't discriminating against King, and they couldn't, so she won. Okay, so that's an illustration of building a prima facie case. The next case is called Stefanko and Doherty and the Maritime Hotel. This is a pretty nasty case about 3 Polish workers at a hotel near in Dorset in the south of England, and they were told to F off back to Poland about 2 weeks after the Brexit poll in 2016 by their alcoholic employer, Mr. Doherty, who was one of the managers at the Maritime Hotel. And they were told to F off back to Poland after one of the claimants asked for her wages to be paid on time. Amongst a number of other things. So they succeeded on claims for unfair dismissal and unlawful deduction of wages. The Employment Tribunal at first instance said that there was no discrimination, but the Employment Appeal Tribunal said that because the claimants were told F off back to Poland and there was evidence of this, it was admitted during the tribunal that actually they did say that, that these were facts from which you could infer, and you must infer under section 136, that there was in fact discrimination. Justice Stacey in the Employment Appeal Tribunal applies the Porcelli principle that the type of insult informs whether or not there is discrimination. So if you use a sexually charged insult, that makes it more likely that there is sexual harassment. If you say F off back to Poland, the fact that Poland is being mentioned means that you are probably being treated less favourably on grounds of your Polish nationality. So the claimants won their claim for race discrimination. Hotel went bankrupt, and so did Mr. Doherty. And then there's Royal Mail Group and FOB. So this illustrates the idea the other way around. This was quite a sad case about a Royal Mail employee who made 30 job applications unsuccessfully. He claimed that the reason he wasn't getting jobs was because of race discrimination, victimization, and harassment. The the Supreme Court ultimately holds that he didn't succeed in his claim because he didn't make out a prima facie case that there was discrimination, harassment, victimization, as he claimed. The burden of proof is on the claimant to at least show some set of facts from which there could be a claim, and you couldn't just decide from inference of not getting a job that there had been discrimination. Okay, so that's the burden of proof. And then there's the remedies. So the kinds of remedies that you can get flow from the fact that discrimination is prohibited if it arises out of a relationship under Section 108 that used to exist between the parties. An employer will be vicariously liable under Sections 109 and 110 for their employees. So if one colleague harasses or discriminates against another, the employer is, at least as a starting point, responsible. Section 111 prohibits instructions by an employer that are discriminatory. Section 112 prohibits unlawful aiding of discrimination. And Section 119 outlines the remedies that the High Court can grant. And the main one that we got to be worried about is damages. So under a case called Vento, there are three categories of damages depending on the seriousness of the discrimination. The low band is under £12,000 for medium level discrimination, serious medium level seriousness. The band goes up to £36,000. This is all 2025, and the top band is £60,000. And you can go beyond that, but it has to really be exceptionally bad discriminatory conduct, probably affecting people's health and safety. There is a 3-month time limit to claim for discrimination, which can be extended if it's just and equitable to do so. Different, strangely, we'll talk about this next time, from equal pay claims based on gender, where there's a 6-month non-extendable time limit. It's also possible at common law to get exemplary or punitive damages under a case called Brooks and Bernard. If the employer does the discriminatory conduct, or in this case the statutory tort, in a way that is calculated to make a profit, then there can be exemplary damages to make an example of the person, to punish the employer for their conduct. A limit on the remedies is that in a decision called Anwar and the Advocate General, the Supreme Court has held that employment tribunals are not able to grant an arrestment of funds or a freezing order, and it's not necessary to implement the principle of effectiveness to allow freeding orders. But that means that tribunals' powers to award remedies are limited. Now, exceptions to direct discrimination are few, but there is sort of one big principle which we find in Schedule 9, Paragraph 1 of the Equality Act. So what we call genuine occupational requirements can be shown as a reason for an employer to justify why there is direct discrimination. So, just to give you an example, a straightforward example, if I am a film company or a theatre company and I have I need somebody to play a man's role as an actor or a woman's role as an actor, I can specify in my job advertisement that I want a man or a woman for that job. It will be a genuine occupational requirement for that particular occupation. So that's a straightforward example of what Schedule 9 does. It articulates a few more examples. Paragraph 2 says that there can be genuine occupational requirements for the purpose of organised religion. Paragraph 3, where religional belief or for religional belief where the ethos and the nature of the context of work makes it necessary to have that particular religional belief. And you can make exceptions for the purposes of the armed forces. In a case in 2004 from the High Court called Amicus, Justice Richards says that because these are exceptions to the general principle of equal treatment, the exceptions have to be construed narrowly. So, for instance, a church is a place of organised religion, but if there are church teachings, not so many now, thankfully, but if there are church teachings against being gay, it still couldn't refuse to hire a gay cleaner because it's not an integral part of running a church to have everybody, including the cleaners, adhering to all bits of the doctrine. Or if you have a religious school, it couldn't refuse to hire a science teacher that doesn't follow the same religion, or a bookshop. So construe the exceptions narrowly. There are explicit exceptions, however, for head teachers at religious or faith schools or heads of universities, although one might wonder why these exceptions still need to be made in 2025. Okay, so under Section 13 of the Equality Act, there is a much larger exception for age discrimination. So as we'll see next time, when we do indirect discrimination, you can make out an objective justification, not just based on the needs of the occupation, but more widely on the needs of the enterprise or the business, if discrimination is indirect rather than direct. In other words, if there's a neutral rule or practice that applies to everyone rather than just targeting an individual with directly discriminatory conduct. You can directly discriminate based on age. For instance, you can set a retirement age, which cuts off people from work at age 68 or 70 or 65 or whatever it is. So long as it's justified for the purpose of the business. So an example of that is Selden, Clarkson, Wright and Jakes. A partner claims, in a partnership firm, claims age discrimination after the compulsory retirement age was set at 65. But the Supreme Court says that this is justified. One of the reasons given by the firm was that they wanted to ensure that new members of staff, new partners could become partners and that there were opportunities opening up. So it was legitimate to have workforce planning in this way. Another thing that I think that we should group with exceptions is this case Ali and Capita Customer Management that we talked about in Working Time, which, if you recall, held that a man could not bring a claim for sex discrimination when women in his workplace got longer paid maternity leave than was available for paid paternity leave, because the court took the view that the predominant purpose of higher paid maternity leave is not childcare but other matters exclusive to the birth mother resulting from pregnancy and childbirth, and not shared by the husband or partner. So on this view, paid parental leave maternity leave is mainly about the mother recuperating. It's not about care for children. Now that seems to be an obviously contestable assumption, but for now the important thing is that what appears to be direct sex discrimination on the basis of fatherhood or motherhood is not being counted by the courts as a problem under the Equality Act. Okay, so the next thing that we're going to look at is harassment and victimization.